Hello everybody and welcome to my channel. I'm Ra and today's topic is Robin Rocky Myers Facing Execution Part 2. If you would like to help out my channel or support my channel, you can become a Patreon, and I will have the part of the article that I used in this part in the comment section with my notes, as well as with the I will also have the article link in the video description box. Now let's get into today's topic. And this starts part 2. Finally, Rocky took the stand. He testified that on the evening of Lottie Mae's murder, he bought crack from Butch and smoked it back at his house. He'd planned to go to a club with his in-laws, but when he arrived at their house, they had already left. On the way back to his house, he said he spotted the VCR hidden under a bush in the alley. Took it to the shot house that night and traded it to Butch for a $20 rock of crack. But he was adamant in stating that he had nothing to do with Lottie Mae's murder. Rocky's testimony raised crucial questions. Why would Lottie Mae have believed that her neighbor needed to use her phone to call his family after a car crash? And why didn't she identify him to the police as her attacker before she died? Years later, Mamie Dutton, her cousin, told a lawyer working on Rocky's appeal that she and Lottie Mae had seen Rocky across the street earlier that day, and Lottie Mae had mentioned that she knew him from the times he had knocked on her door asking for ice. And Rocky surely knew that Lottie Mae lived alone. Yet on the night of her murder, Dutton said she'd heard her cousin tell her attacker that her husband was in the other room. Puckett, the juror, noticed these holes in the prosecution's case. It was the state's place to prove that Rocky Myers was in the home and committed the crime. In my mind, it never happened, she said. I kept waiting for the word that was going to tell me what happened, and there was never one. There was never that aha moment. But Puckett said the deck felt stacked against Rocky from the beginning. During jury selection, one juror said that if the suspect made it through a grand jury, he was automatically guilty. She remembered that another kept referring to the VCR as rabbit tracks that proved his guilt. A decade after the trial, when Keaton took over Rocky's appeal, she and Sarah Ramone, an investigator assigned to the case, interviewed another juror who openly used a vicious racial slur to refer to Rocky and called him a thug. Puckett recalled that at least 3 other jurors didn't believe that there was enough evidence to convict Rocky, but as they had tried, Puckett and the others who shared her uncertainty could not get the rest to budge. 11 of the 12 jurors were white, and most were set on voting guilty. According to Puckett, the group of unconvinced jurors feared that if they did not find a compromise, the outcome of the trial would be a hung jury. In that case, Rocky would be retried in front of a new jury that could have fewer sympathetic members, and increasing the chances that he would be sentenced to death. So they reached an agreement. They would vote for a guilty verdict along with the others in exchange for the recommendation of life without parole. We were dealing with ourselves, trying to come up with a way to save his life, Puckett said. And that's what it boiled down to. Rocky was thus convicted of capital murder by a margin of 9-3. The jurors provided their agreed-upon recommendation of life without parole to the judge. The verdict came as a stunning blow to Rocky, who'd been convinced that the trial would end up with his acquittal. I was surprised, he said in a phone interview. I thought I was going back to New Jersey. A few months later, Puckett at her home outside of Decatur when she got the call from one of the other jurors. The judge who presided over the case had exercised his his option to a judicial override, disregarding the jury's recommendation of life without parole, sentencing Rocky to die instead. From the bench, he said, the jurors were being too emotional in choosing not to recommend the death penalty on its own and described Rocky as a threat to society. I never thought for a moment he did it, said Puckett, her voice cracking. We struggled over our decision for good reason, and if we were emotional, it was valid. How could someone do that without emotion? Would you want someone like that on a jury? Since 1976, when the U.S. Supreme Court ruled in Gregg versus Georgia that capital punishment was constitutional, only 3 states have ever allowed the practice of judicial override in death penalty cases: Florida, Delaware, and Alabama. In 2016, the U.S. Supreme Court ruled that Florida's judicial override statute was unconstitutional. That same year, Delaware Supreme Court banned the practice in that state. Alabama's use of judicial override was the most notorious. Before the practice was banned by the state legislature in 2017, an Alabama-based legal advocacy organization called the Equal Justice Initiative calculated that 20% of inmates on death row in Alabama had their sentences imposed through judicial override. 3/4 of such cases involve a white victim. Though only 35% of homicide victims in the state were white. In Alabama, state judges were elected by popular vote, and they often emphasized their tough-on-crime record while campaigning. According to another Equal Justice Initiative study, the use of judicial overrides to dole out death sentences in Alabama often spiked during election years. In 2013, the Supreme Court declined to hear a challenge to Alabama's judicial override statute, but Justice Sonia Sotomayor, and I'm sorry if I said her last name wrong, wrote in dissent that judges in the state appear to have succumbed to electoral pressures. In Rocky's case, the judge who imposed his sentence was facing re-election the next year. Although the practice is no longer permitted in Alabama, the state passed that the legislature was not reactive, which means that anyone put on death row by judicial override stayed there despite the legislator's tacit acknowledgement that the practice was unjust. After his conviction, Rocky was transferred to Holman Correction Facility, where Alabama carries out its death sentences. His trial lawyers filed an appeal, which was unsuccessful. Once the appeal of a death row inmate initial conviction is denied, there is a lengthy Byzantine, not sure if that's right, post-conviction process that can last for decades. The habeas corpus process offers inmates the process to present new information in the trials and dispute the underlying rationale that led to their conviction. This is the stage in the death penalty process where many sentences have been overturned on the basis of poor representation by counsel at trial, procedural errors, and the recanting of witness testimony or new evidence of misconduct by prosecution, police, or juries. In 1998, a young Tennessee-based lawyer named Earl J. Swartz agreed to represent Rocky in his post-conviction appeals. Until 2017, Alabama did not automatically provide counsel to death row inmates during this stage of their appeal. So the American Bar Association and other legal advocacy groups sought out lawyers like Swartz to work pro bono on death penalty appeals in the state, and pro bono just means for free. Swartz worked on Rocky's case for over 5 years as it made its way through the state appeals process. In 2003, he received notice that Rocky's petition for a conviction appeal had been denied by the state. The next process was to prepare a file to a federal corpus petition. Federal corpus sorry about that. Habeas corpus. I'm so sorry that I'm saying these names wrong. I mean, these words wrong, but they're really difficult to say. Federal habeas corpus review is a critical stage in the death penalty case. Because it allows death row prisoners to bring federal constitutional claims that were heard in state court that were not successful, said Anna A., senior staff attorney with the ACLU Capital Punishment Project. Disclosure: the author is a staff reporter at the ACLU and federal court, where judges are appointed and not elected, is a very different atmosphere for a prisoner. But by then, Swartz had begun working at a new law firm and inexplicably did not tell Rocky his state appeal had been denied. This was a devastating moment, though Rocky wouldn't know of it for another year. Mr. Swartz decided that he could no longer represent Rocky, but unfortunately he just sat in a room and said that quietly to himself, said Keaton. He didn't tell Rocky. He didn't call the courts and let them know. He didn't tell prosecutors. He just quit doing anything. In an email, Swartz said that when he joined the new firm, he lost a 4-person team working on Rocky's case. I should have returned the file to the Equal Justice Initiative at the time. I didn't. That's on me, he wrote. A year later, Rocky received a letter from the state's attorney's general office saying that he had missed the deadline to file any further habeas corpus. There we go. I'm sorry that I said that word wrong up earlier. Petitions, and notified him that Alabama would be moving to set an execution date. Rocky could only read at a 3rd grade level and had to ask another prisoner to read the letter out loud. In a recent interview, Rocky said that when he realized that what the letter meant, it scared the crap out of him. Okay, it scared the crap out of me. I mean literally. I didn't know what to do. I was shaking. I couldn't breathe. A couple of guys calmed me down and told me what to do. The prisoner who read the letter to Rocky was represented by the Equal Justice Initiative and reached out to the organization to ask for help. Frantically, attorneys working there called the Capital Habeas Unit of Federal Defense Office for the Middle District of Alabama, asking if defenders assigned to the unit could take up Rocky's case. They filed a habeas petition, but it was too late. The state of Alabama argued that Swartz's failings were irrelevant, contending that the burden had been placed on Rocky to stay on top of his case. And the U.S. Court of Appeals for the 11th Circuit agreed. They said, yes, we showed that Swartz's failures were a problem, but Rocky, even with his intellectual disability, had showed some level of diligence on his part. Sorry, had to show some level of diligence on his part, said Keaton. We had affidavits that showed habeas corpus language that is above college level in terms of reading and understanding, and that Rocky reads at approximately a third or fourth grade level, so that will never make sense to me. A lot of people think that people on death row know the law. They know this or that, and I don't, said Rocky. I gave all my trust to my attorneys and stuff. If I could read the law in the books and learn and study, I would, but I am not able to do that. I'm not a learnable type of person. When fighting for a deadline extension in court, lawyers working on Rocky's case heard a shocking story from Marzel Ewing, Rocky's acquaintance, who had testified to having seen him trade the VCR in the shot house. Around the time homicide detectives shifted their focus away from Cool Breeze, Martell was arrested while driving a stolen car in Decatur. Marzel told the attorneys that one detective had offered to make the arrest disappear if he would say he had seen Rocky bring the VCR to Butch at the shot house. In the declaration that Marzel signed in late 2004, he said that his testimony during Rocky's trial was not truthful. I did not see who brought the VCR to the shot house that night. He further stated that Detective Boyd told me that he would take the stolen car that I was driving and leave it by the side of the road. Police reports from the time support his story. 2 suspects were indeed arrested in a stolen car, matching the one described by Marzel on October 28, 1991, the same day Boyd's notes indicated he first interviewed Marzel. The evidence that that police indicator tampered with at least one suspect was a bombshell. It did not entirely contradict the prosecution narrative. Rocky had, after all, already admitted to trading the VCR to Butch, but it raised powerful questions that the conduct of the Decatur police during the investigation. In the federal court, Marzel's declaration, along with Puckett's account of the jury's compromise verdict, compromise verdict, might be a minimum have called the death sentence into question, if not the conviction itself. But it still wasn't enough. A federal court ruled that Marzel's new statement didn't override Rocky's failure to meet the habeas corpus deadline. Even with new evidence, the case was effectively closed. With the doors to judicial review shut, the only remaining relief was and still is intervention by Alabama's Governor Kay Ivey. Swartz later signed a declaration admitting that he did not tell Mr. Myers I was no longer representing him, and that he didn't inform Mr. Myers that I would not pursue relief on his behalf in the federal court. The Board of Professional Responsibility of the Supreme Court of Tennessee issued a public assure to him in 2005, saying that he willingly neglected his representation of his client. In 2018, Swartz was elected president of the Memphis Bar Association, which states that the one of its responsibilities is to ensure and assist lawyers in maintaining and improving their competency so they can better serve their clients and the public. Rocky Meyer remains on death row. Rocky lives under near constant lockdown in Holman, sometimes going days without yard time because the staff shortages in Alabama Department of Corrections. In a phone interview in early February, he described a somber atmosphere of prison's death row, where a friend of his named Dominic Ray was scheduled to be executed the week we spoke. At times like this is when everyone's mostly quiet, he said. TV is down very low. You can hear a pin drop. Days later, Ray was executed after the U.S. Supreme Court denied his request to have a imam, I'm not sure what that means, present in the legal injection chamber. When I'm praying, I tell the Lord I'm terrified, Rocky said. I just don't show it because it don't do any good to other people. But inside of my mind and heart and stomach, I'm scared. A former church drummer, Rocky attended services regularly, singing in the choir that meets once a week. His children are grown now, with children of their own, some of whom he met during a visit for the first time last year. Rocky says that being separated from his family has taken a toll. It's one of the worst things I'm going through. I have grandkids that are growing up without me. Rocky's legal team checks in on him regularly with in-person visits and by phone. Getting him to understand what's happening in his case at any given moment is definitely a challenge, Keaton said. We have clients who send us written communications, but Rocky cannot write anything to us. In 2012, an execution date was set for Rocky, but Keaton managed to add his name to litigation challenging Alabama's lethal injection protocol. That litigation was dropped last year after the state agreed to offer asphyxiation by nitro gas as a execution option. Now Alabama is working on a protocol for a new method, after which Rocky will be given a new execution date. The only chance for Rocky to avoid execution now is a grant of clemency by Governor Kay Ivey. Both he and Keaton know it's a long shot, and initially he told her not to pursue it. I did not want to be over there begging for my life and stuff like that, he said. But Keaton persisted. The fact that we were potentially executing a man who didn't have the day in court because a lawyer screwed up should give everyone pause, Keaton said. Rocky says it's frustrating to watch other prisoners get breaks in their cases and be released while he's been effectively shut out of court. There's a lot of people who support the death penalty, he said, but to know that there are people on death row that is or could be innocent, how can you support that, I hope you enjoyed this video. It wasn't really about enjoyment. It's not why I did this video. Please share your thoughts in the comment section below. I just really hope that these videos get Rocky and his family justice and brings Lottie Mae's actual killer um to the surface, because I know I shouldn't put my thoughts in here, but I don't think that Rocky Meyer did this. But I'm not, of course, I don't know who would have killed Lottie Mae, and I'm sorry to Lottie Mae's family and anyone of her loved ones, as well as I'm sorry to Rocky Meyer's family and his loved ones as well, because I feel like this case wasn't done to the way. There was a lot of wrongs that were done in this case. As some of you may know, I have problems with pronunciation because of my learning disability, but I don't try to hide that from people, because I know people have similar struggles to the ones I have, and I want them to know that they're not alone. No matter how hard pronouncing some words can be, I always try my best. Those are the reason I keep my mistakes in these videos. I'm open to any suggestions you have for any future videos. Please let me know whether in the comment section below or on my Twitter page, and my Twitter handle is @BurleyMariah. That's my last name, then my first name. I can spell it for you. Burley, that's my last name. Then my first name is Marih. The next video will be on EDS is. Then that video will be available on my YouTube channel on May 21st at 6 p.m. EDT time. I hope everyone's continuing to stay safe. I will post my notes in the comment section for anyone who needs them. Again, please like, share, and subscribe if you found this video to be helpful. Feel free to share this video with anyone you think would benefit from watching it. If you want to be notified when I do any live streams or upload any new content, you want to click the bell icon under